Everybody's probably heard of a Good Samaritan Act, and you probably know a little bit about what that means. Most of the time when you define or you ask people what does a Good Samaritan Act do, they think of a side of the road situation where a doctor stops or a nurse stops and provides some kind of emergent medical care to a person, and then the person, for whatever reason, that care makes their situation worse, and then the person wants to consider some kind of lawsuit against the person that provided that care on the side of the road. Well, for a long period of time, I think back in the 60s, Florida has had a Good Samaritan Act that covered people in those situations and didn't allow for you to be successfully sued for that kind of care. But it wasn't until more recently that the legislature decided to try to extend the Good Samaritan Act into the hospital itself. So Chapter 768 13 of the Florida statutes actually encapsulates this Good Samaritan Act within the hospital, among other things. But within the hospital, basically, I'll let Dr. Malone speak to this, but basically if you're considered an emergent patient and you're not stable, then whatever care is rendered to you is covered by this act. And it doesn't mean you can't sue for it. It just means that you have to prove a higher standard of negligence or reckless behavior, basically, reckless disregard for the health and safety of the patient in order to prove your case. And in a regular negligence case, you just have to prove that it wasn't reasonable care. So it is a heightened standard for those emergent patients who are not capable of receiving non-emergent care, those unstable patients that are not capable of receiving non-emergent care. I guess what it comes down to, doctor, is what defines a stable patient and what defines somebody not capable of receiving non-emergent care. What does that mean to you as a physician?
So as a physician, I take the term stable or unstable, that's a condition that people are admitted to the hospital with many times, where they're admitted as stable or they're admitted for observation, they're admitted critically ill. That critically ill could also be unstable. So does it apply with the Good Samaritan Law where they're unstable throughout the duration of their hospitalization, therefore Good Samaritan applies across the board? I don't think so. I think what this is intended for is unstable in the acute presentation in an ER setting where emergency room personnel are providing care within their scope. And if they go outside of that scope, then perhaps they're, displaying reckless disregard, and you have an unstable patient, then it doesn't matter if they're unstable or stable, it's the reckless disregard. Now, if they're practicing within their scope to the standard of care, providing you the services that you require, the services that are available at the hospital, and things still do not work out and you were to have a complication or die, then according to the statute, they, are free of any liability.
Right. I think what I'm asking you, though, and I think you're answering this, you can be critical, but also be stable.
Yes.
Explain that.
Okay, so stable means they've done everything to their capacity to get another level of care, meaning another set of providers, a subspecialist involved in your care, more testing involved in your diagnosis, or hopefully definitive treatment, so getting IV antibiotics. So you can be unstable with an infection, be started on antibiotics, and then I would deem that as being stable, like we've started treatment. Right. And then if you don't do well 3 days later, it's not because you're unstable at the outset, it's because you became more unstable or you did not tolerate the treatment.
As you can see from just this discussion, there is some gray area here, and where there's gray area, there's going to be some party saying that the statute protects them, and there'll be another party, us, saying the statute doesn't protect them and the reasonable care is required. The reasonable care standard applies and not the reckless disregard standard. Obviously, as a plaintiff, you want to be able to prove your case at a lower level of proof than a higher level of proof, because then that means you have to have even more evidence and convince the jury that the doctor did something beyond just negligence, which is it's hard enough to prove that they're negligent sometimes. It's because they get the benefit of the doubt most of the time. Like I tell my potential clients, or doctors, you walk in a courtroom, doctors get the benefit of the doubt 9 times out of 10 without anybody saying a word. So proving negligence is hard enough. Proving reckless disregard for the health and safety of a patient is even harder. So it's important that you visit with an experienced medical malpractice lawyer when you have your meeting with a potential lawyer. If you're a potential client looking for a medical malpractice lawyer, you should also make sure that that lawyer handles medical malpractice cases as part of their business model. They don't just dabble in it. We here at Zarzaur Law are obviously set up to handle medical malpractice cases. Having a full-time physician on staff helps that endeavor. If you have questions about the Good Samaritan Act and as it applies to medical malpractice cases, you can always find us on the web or call us at 855-HIRE-JOE. I should also mention before we close this discussion that this particular act also deals with EMTALA, which is the right to be treated at an emergency facility and stabilized before they can kick you out. The federal statute and the EMTALA statute has been in play for a while, but this is the state version of the EMTALA, which basically says that if you show up in an ER, they have an obligation, no matter what your financial situation is, to stabilize you before they kick you out. They don't have to accept you as an inpatient necessarily, but they do have the obligation under this statute and the federal statute to make sure that you're stable before they tell you you have to leave. All right, if you have any questions about it, you know where to find us. Thank you very much.